Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Up next, there is Silas Bowling.
Your Honor, this is Mr. Silas Bowling. This is a violation of probation. Mr. Bowling has already entered a plea admitting the violation, so this is all that's left is to determine sentencing. He was furloughed and turned himself back in from the jail after leaving the treatment program, and we're asking for a hearing on the issue of sentencing.
All right, if you're ready for a hearing, stay ready. All right, we'll have your hearing. So my understanding is that the defendant has already been found guilty of violation of probation. It's just a matter of what the disposition will be. State, want to put on any proof to begin with?
Can you state your name for the record, please?
Angel Nyamtu.
And were you the supervising officer for Mr. Bowling?
I was.
Okay. And did he previously admit to his violation, which I believe at that point in time was an original amended first and second amended violation of probation?
He did. I believe there may be one that is.
Or maybe I said it wrong, violation amended and second amended.
Yes, so that was on August of 20th, 2024.
Okay. And let's see. And was one of those conditions that he admitted to at that point in time was that he had been discharged from the Hope Center?
That's correct.
Okay. And then he further, when he admitted and waived, he was allowed to furlough. Is that correct? At this most recent time?
I apologize, I cannot recall.
Well, what we're here for today.
It looks like so he admitted, waived, and revoked in August. Unfortunately, I don't have notes beyond that.
If
But
the
I do
court
know-
records show that he was furloughed to the Jack Jean Center, does that sound correct?
Yes, he was transported to Jack Jean, and then there was status set for March 25th, 2025.
Did Mr. Bowling successfully complete the Jack Jean shelter?
It is my understanding that he did not. At that time, he was under the supervision of Officer James Ward.
Objection to the foundation. How would she know this information?
Does your office maintain records
Yes, we do.
as a component of the official business of probation and parole?
Yes, it does.
And are you aware of, or should Officer Ward be the one to testify in regards to the status of Mr. Bowling after he went into the Jack Jean shelter?
I could testify that he didn't complete. Officer Ward would have any status updates from that time.
Okay.
Renew my objection to the lack of foundation.
Overruled.
And do you have access to that status update?
As a normal course of business, yes.
Okay. Are you aware of whether or not that status update was submitted to the court as the normal course of business?
That I'm unaware.
Okay. Thank you. I don't have any further questions.
Talbot?
You testified earlier to, I think, a first violation, an amended violation, and then a second amended violation.
Correct.
And those were all disposed of together in August 2024?
From my notes, I do have that.
Okay. And before you filed the set of violations that started off those, did Mr. Bowling have any other violations on probation? Like
He
before
did
that?
have a previous violation that was disposed of. That one was written July 20th, 2023. Now, just one second. And then for that violation, he admitted, waived, and reinstated to probation on September 27th, 2023, with the conditions that he complete long-term treatment.
And is there a recommendation that you're making to the court about the disposition of this sentence?
Today,
Yes, ma'am.
I recommend that Mr. Bowling just go ahead and serve his sentence. He's been given multiple opportunities to complete long-term treatment. He keeps not completing those successfully.
If your testimony is correct the way I understand it, then this would be what we're dealing with today is the second set of violations that he's had. Is that right?
Correct.
Thank you.
Redirect.
So, Mr. Bowling, you were asked about the September of 2023 violation. Is
Yes.
that when Mr. Bowling was allowed to go back onto probation with the agreement that he complete long-term treatment, and that was the Hope Center?
We indicated to complete long-term treatment. He was going to go to Jack Jean, but there was a long wait, so we did say he could go to Hope Center.
Okay, and that's the one you testified to previously, or is that the one you testified to previously that he did not complete? One of the ones that he did not complete.
He did go to Hope Center. He did not complete.
Okay. And then the one we're here for sentencing, what was the date that he admitted on? I'm sorry, I don't have that paperwork in front of me.
August 20th, 2024.
Okay. And he was on a furlough at that point in time.
Correct.
I don't have any other further questions. Thank you.
Anything else? Thank you, officer. You may step down and have a seat in the courtroom. State, have any other witness?
Record, please.
James Ward.
And did you take over the supervision of Silas Bowling after Officer Nyam too?
Yes, I was monitoring his case out of Jack Jean.
When did you take over the monitoring?
About August of 2024.
Okay, so once he was furloughed from the jail to Jack Jean, is that correct?
Yes.
Okay. And did you receive any status updates from Jack Jean?
Yes.
Did you typically submit them to our office and the public defender's office in court when you received those?
It was my understanding with the monthlies that I was getting, that was being submitted by Jack Jean directly to the public defender's office and the DA.
Okay. Did Mr. Bowling successfully complete the Jack Jean shelter?
He did not.
Okay. And Your Honor, may I approach?
You may.
Yeah. Yeah. Thank you.
You tell us, you have a copy in front of you. Can you tell us the reason for the discharge of Mr. Bowling?
On May
Make an
8th,
objection. I'm making an objection to the hearsay.
Overruled.
on May 8th, 2025, he was discharged from the Jack Jean Shelter for Women and Men for riding a motorcycle to and from work despite not having a license, insurance, and against the recommendations of the program leader.
Was it a condition of his last violation that he must complete treatment?
Yes.
Thank you. I don't have any further questions.
I have nothing to ask. Thank you, Your Honor.
All right, thank you, Officer Ward. You can step down. Any other witnesses? All right. State has rested their proof. Mr. Talbot, do you wish to put on any proof?
Yes, please, Your Honor. I'll call Mr. Silas Bowling.
Bowling, if you'll come around, please. I don't think he's going to be able to stand up to the best of your ability to raise your right hand.
What's your name, sir?
Silas Bowling.
And were you participating at the Jack Gene program?
Yes.
Okay. From when did you start there?
It was September the 11th,
Of,
2024.
and when did you leave that program?
I ended up turning myself in May 9th, so it was May 8th.
Of this year?
Yes, sir.
Okay. And you turned yourself in. Where did you turn yourself in?
In Dickson County.
Okay. Did you turn yourself into the jail?
Yes, sir.
Is that what you're saying? Okay. And you've remained in jail the entire time until this hearing date?
Yes, sir, that's correct.
Are you asking the court to reinstate you to probation?
I would.
Do you feel like you made progress in the program at Jack Gene, although you didn't finish it?
I'm 18 months clean. I've never been this clean in my life for this amount of time. I did something right there.
I'll pass the witness, Your Honor.
Joe?
Mr. Bowling, this was not your first violation, correct?
No, ma'am.
In fact, you previously were allowed to go to the Hope Center, correct?
Yes, ma'am.
And then after not completing the Hope Center, you were again allowed to furlough to the Jack Gene.
That is correct.
And you turned yourself in to avoid getting an escape charge, is that correct?
I did it because it was right, not because I was avoiding an escape
Okay.
charge.
But you did get to avoid an escape charge, so you turned yourself in
Yes,
this
ma'am.
last time. Okay. And, Your Honor, may I approach the witness?
You may.
My signature. It says, "Dear District Attorney, my name is Silas E. Bowling. I have filed a motion pro se for a hearing of my violation of probation hearing, asked for the soonest court date possible and a plea of revoke to serve. I went to rehab, left, and came back into Dickson County Jail and turned myself in. I am still clean, by the way. I would like to ask you to help me put this behind me so that I may prove forward with my life by getting a court date and a hearing to plead revoke to serve. When I went to court last time to get my furlough, my rehab attorney was PD Zachary Talbot."
Mr. Bowling, did you, at that point in time that you mailed that letter, want to just go ahead and put your sentence into effect and flatten it and be done?
I was hoping for,
Objection to the relevance of this.
Goes towards sentencing, Judge, and it's obviously his request that he sent.
Overruled.
You could answer it.
I didn't even really know this was getting sent out.
Okay. It does say to District Attorney, doesn't
Yeah,
it?
this is definitely not my handwriting. It's my signature, but that's definitely not my handwriting.
Okay.
All right. Working as exhibit to this hearing.
Your Honor, I object. I don't believe the witness has authenticated that as a document that he authored. He did say it was his signature, but I think he wasn't sure that it was his handwriting. I don't believe it's properly authenticated.
I understood you to say it's your signature, but you're not sure it's your handwriting?
No, I know it's not my handwriting. That is my signature. Yes,
Someone
sir.
else wrote it and you just signed it?
Yes, sir.
Overruled.
I don't have any further questions.
Mr. Talbot, you have to redirect.
Mr. Bowling, is it today your wish that your entire sentence be put into effect? Or
No.
are you seeking a different outcome?
A different outcome.
And I'm representing you in this proceeding?
Yes, sir.
Okay. And, oh, that's it. Thank you.
Why would you leave, why would you do something in violation of the rules of the Jack Jeans Center when you were being successful up to that point?
Your Honor, if I may, I had a worked out plan with Bruce Mays, the director, that I was going to purchase a motorcycle. It was to be on Jack Jean's grounds. And we had worked out that because I had just took my test for the motorcycle, I had done the written test, and I was supposed to take the driver's test that Friday. He told me as long as I had it, and I didn't drive it from to work. I don't know where that came from, but it never went from that place. It was locked up in the shed. And whenever he told me I could take it out, the guy who drove it that I was buying it from, because I haven't even purchased it yet, I was going to, that I was going to practice in a church parking lot that had cones so I could do the figure eight with my foot never to touch the ground whenever I'm doing the figure eight, so I could pass the motorcycles test and actually be able to drive. But I never made it to that.
Why?
I had upset two of the people at Jack Jean, and I'm pretty sure that came to my demise.
You upset him by talking back to him, or what?
No, Your Honor, I put my nose where it shouldn't have belonged, plain and short.
So you have remained drug-free, and you've gone through this program and done it, but you understand the condition of your probation being reinstated was
do.
that you had to successfully complete it.
I do understand,
And
sir.
it's the second time that you have been given that opportunity. You understand that?
Yes, Your Honor.
All right. Thank you. Step down. Anything else, Mr. Talbot?
No, sir.
State have any rebuttal? You wish to be heard in argument?
Thank you, Your Honor. Shall I come up to the podium? Yes, sir. As the court is well aware, on a second set of technical violations, where the defendant is found in violation of technical violations, the prescribed sentence is 15 days in jail. That's what the statute requires. So we ask that we ask the court to enter that sentence. The defendant has already served well over that period of time. We tried to get him into court sooner than this hearing date, but we did have to set it on this day. He served plenty of time, which addresses the 15 days that the statute prescribes for a violation or violations of this nature. And we ask the court to order that sentence and reinstate him to probation. Thank you.
General?
Mr. Bowling has previously already admitted and waived. He also furloughed. This was a condition of his sentence was to complete it. It was a furlough. It was not a technical violation. I would ask for him to be revoked to serve.
There is a distinct difference in having a hearing where the person is found guilty, and then we have a hearing to determine whether or not what the sentence should be. In this particular case, he has previously been found guilty of violation of probation in September of 2023, and he was reinstated to probation. A condition of his probation was to complete a long-term rehab program. I signed that order. He did not complete that long-term treatment program, and therefore was brought back before the court on another violation of probation after he left the Hope Center. And he was then given another opportunity. And in that situation, he was, if I recall correctly, fully revoked to serve his sentence and then given a furlough. Lay my hands on it. So the plea that was entered in August of 2024 was that he would admit his violation, waive the hearing, he would be furloughed to the Jack Jean Center, and then would be set for a hearing to determine that. I don't know whether it is true what Mr. Bowling has said about the circumstances of his leaving, but the fact is that he was given an opportunity on 2 occasions to be reinstated to probation on the simple condition that he complete a long-term rehab. And whether it's his stubbornness over this motorcycle or his stupidity for violating the order because of the fact that what was going to be at risk, that's neither here nor there. But the fact of the matter is that he did not complete the conditions of the reinstatement of his probation. Actually, it was not guaranteed that that would be reinstated. It was set for a sentencing hearing. Therefore, I find that he is in violation of his probation, clearly as he has admitted, and I do not have anything before me that would indicate that he would be any more successful for reinstatement, more successful in a rehab program than he has been on the 2 prior occasions. So therefore, he's remanded to serve out the balance of his sentence with credit for time served.
Judge, up next is Juan Brooks.
All right.
If I may interject on Mr. Brooks, if we could second call that, I would like to speak to Mr. Brooks.
We'll put a second call.
Thank you, Your Honor.
Next, Shane Butler. Next up, Shane Butler, Judge.
Shane Butler. All right, this is the State of Tennessee versus Shane Butler, wherein Mr. Butler is charged with violation of his probation. State ready? All right, call your first witness.
Are you Officer Keith Moore with the Tennessee Department of Corrections?
Yes, ma'am.
And do you currently supervise Shane Butler?
I do.
How long has Mr. Butler been on probation?
Since 9/18/2023.
Is this his first violation?
No, ma'am.
Could you explain what happened on his previous violations?
Yes, he was at Safe Harbor, and he left the program without permission of his officer. We talked to them and
Well,
got him.
that's his current violation. Let's talk about his previous. What's
I'm
happened
leading up
before
to
we
that.
got, okay.
It's the same thing. He left Safe Harbor without permission of me back in 3/28/24. We talked to the program, got him back into the program on 4/15/2024. They accepted him back again, and then 5/1, he exited Safe Harbor for, he had failed drug screens, and so we brought him into the office to do a drug screen and get him an emergency VHS appointment. He did that VHS appointment and
Wait, pause. VHS?
I'm sorry, behavioral health specialist.
Okay, thank you. Go
So
on.
he did the emergency behavioral health specialist appointment. He admitted to me that he shouldn't have left the program and that he wasn't ready to leave the program. So we got him into Tony Rice per that treatment program. And he lasted 2 days, and a girlfriend came and picked him up, and they said he was non-compliant at the program. And so we started the process of a graduated zero tolerance. Basically, he was sanctioned for leaving the program because it was an order from treatment to do that. So he didn't take advantage of Tony Rice and left. And then he absconded until January of 2025. And that's where his first violation came from on I believe it was 2/26 he was in court. 2/26 he was in court.
And on that violation, he was sentenced to serve a period of time and then again instructed to complete a rehab program?
Correct. He was given 180 days to serve. I guess whatever he had going on, he was time served basically once that was done. And they accepted him back at Safe Harbor again. He had called the admissions coordinator in January to ask him, tell him that basically he was done absconding and he wanted to come back and get help and he wanted to get back in the program. A lot of times they don't take you back after that many times. And this admissions coordinator really cared about him and talked to the director, got him back in again, put his reputation on the line again to get him back into the program. And so that was where the special condition came from, is that he wanted to go to Safe Harbor. He asked for it. Well, he got to serve or go to Safe Harbor in February. He agreed to that.
How long did he make it in the Safe Harbor program?
It looks like he was compliant until July, when he was discharged for failed drug screens there, which would have been alcohol and kratom for them.
How long is the Safe Harbor program?
1 year.
When he left Safe Harbor, did he report back to your office?
He did not report to the office. However, he did report to me. It could have been a violation right then and there, but I really wanted him back in. I talked to the admissions coordinator again. They talked to the director again, and they offered to bring him back in, and he agreed that he would come back. He said he was dealing with some family issues, but we allowed him just a grace period there, which he didn't have to have a grace period, but we allowed him to have that before we violated him. He then said, we gave him instructions to report on 7/28 back to the program. He agreed, and then he didn't report on 7/28. 7/29, he stated, I will be there by the end of the day, and he did not return. And so now he's not welcome back there, but also he has not returned there since then.
What is your recommendation at this time?
I don't believe he's a good candidate for probation. He has been offered many treatments. He's been in treatment and the very good treatment programs, and he kind of comes and goes as he pleases, and I believe he should serve his sentence.
Nothing further, Judge.
Howard?
Mr. Moore, you did take out this violation personally, correct?
I'm sorry, I didn't miss the last part.
You did take out this violation personally, correct?
Personally.
You prepared this
Yes.
affidavit, and it was turned in on the 25th of August, 2025, is that correct?
Yes.
And it appears that the only box that is checked is technical only, is that also correct?
Yeah, that's because, do you want me to explain it? Yes.
I'm just asking what the
Yes, I
affidavit
checked
says.
out technical only.
Okay. And you went through a long history there with General Bryson of prior violations. How many prior violations by your count are there?
He has 2 prior and then this one, third.
Okay, so that'll make it a third,
Correct.
right? And it's only a technical violation per the affidavit you submitted.
Correct. It's a violation of his special conditions, which are ordered in court, which is a use of sanction not permitted by a judge, which is technically zero tolerance.
You are aware of 4035-311, which states that a third technical violation is not to exceed 90 days. Is that correct?
If you're telling me that, yes, sir.
Wait, nevertheless, you're asking that he be revoked to serve in full today?
Yes, sir.
Nothing further.
Anything further? Step down. They may call your next witness.
No further proof, Judge.
Howard, do you have any proof you wish to offer? Then I'll hear you an argument.
Judge, the box on the warrant says technical. The rules of the court say zero tolerance. A zero tolerance violation includes those for any offense mandated by the court. The court previously ordered him to complete this treatment. It was his, by my count, 5th attempt to do so. It's time to be done.
Howard?
Record and the affidavit before the court reflects a technical only violation. The court has heard testimony that it is a 3rd violation at best. I would request that the court not sentence Mr. Butler to any more than 90 days as prescribed by the statute.
The plea that was entered in this case was entered on February the 26th of 2025, states the following. It was a violation of probation, and it stated that the defendant admitted his violation of probation, was ordered to serve 180 days to serve, reinstate to state probation. The condition of his state probation was the completion of an inpatient rehab of Safe Harbor. And I agree with the state that, while I understand the technical violation aspect of that, this is a violation of a court order, and the court order, in my opinion, trumps the idea that the statute says a technical violation, mandatory sentence, or the mandatory maximum sentence is 90 days. In this case, the only reason he was reinstated to probation was if he completed the Safe Harbor program, and he did not do so, and as a result, the court finds that he is in violation and should be revoked. He's been given ample opportunity to try to get himself straightened out. I do not find that there's any reason to believe that he would be reinstated to probation successfully. Therefore, he is revoked the service sentence.